Marbury versus Madison. Sounds like a boxing match. Well, not exactly, but it is a hard-fought contest for high stakes. In this corner we have James Madison. Yes, the James Madison, alias father of the Constitution. And in this corner we have William Marbury. Who's that? It's 1801, and President John Adams has just lost a hotly contested election to Thomas Jefferson. In the waning hours of his presidency, Adams appoints numerous judges to the bench. One of these so-called midnight judges is William Marbury. Well, President Adams signs Marbury's official commission, and he stamps it with a presidential seal. But there's not enough time for his Secretary of State to deliver it. And it's not a done deal until it's signed, sealed, and delivered. William Marbury expects his official commission to arrive any day, but it never comes. Why? President Jefferson has ordered his new Secretary of State, James Madison, not to honor the commission, so Jefferson can appoint the judges he wants. Understandably, Marbury is ticked. He files suit, demanding that Madison deliver his official commission. Hence, the celebrated court case that has shaped the course of our nation, Marbury versus Madison. John Marshall, Chief Justice of the Supreme Court, basically agrees with Marbury. Madison should have delivered the commission, which was officially signed and sealed while Adams was still president. But, and this is a monster but, the Judiciary Act of 1789, which purportedly grants Marbury the right to file suit in a case like this, actually violates Article 3, Section 2, Clause 2 of the Constitution. In most cases, including this, the Supreme Court has only appellate jurisdiction. This means Marbury should have taken his case to a lower court first. We see this today. People file suit in lower courts. Only later can they appeal to the Supreme Court. On one level, this seems like a mere technicality. But on another level, Chief Justice Marshall establishes a lasting precedent. Courts can nullify a law by declaring it unconstitutional. Written constitutions form the fundamental and paramount law of the nation. Consequently, an act of the legislature repugnant to the Constitution is void. It is emphatically the providence and duty of the Judicial Department to say what the law is. Today, we call this judicial review. The Supreme Court can invalidate an act of Congress or an executive order by the President if it violates a provision of the Constitution. Marbury versus Madison is super important, but it was not the first use of judicial review. In 17 prior cases, courts had invalidated legislative acts, but none of these played on the big stage, a clash between a sitting president and a former president. Several framers at the Constitutional Convention voiced approval of judicial review. Alexander Hamilton: no legislative act contrary to the Constitution can be valid. Therefore, it is the duty of the courts of justice to declare all acts contrary to the Constitution void. Without this, all the reservations of particular rights or privileges will amount to nothing. And yet, the framers did not explicitly empower the Supreme Court to declare laws unconstitutional. Why? Here's my conjecture. Since judges should not cater to public opinion, the framers determined they should not be chosen directly by the people. And yet, to get the Constitution ratified and take effect, the people would have to approve it. And granting a small group of unelected officials the power to overturn the representatives of the people would be a hard sell. Best to leave it implied, not stated outright. For over 2 centuries, judicial review has played a major role in shaping our nation. In 1896, with Plessy versus Ferguson, the Supreme Court enshrined racial segregation in public places, saying that separate but equal was just fine. But in 1954, Brown versus Board of Education, The court ruled unanimously that segregated schools violated the Equal Protection Clause of the 14th Amendment. In 1973, with Roe v. Wade, the Supreme Court declared that laws banning abortion violated a woman's right to privacy enshrined in the 14th Amendment. But half a century later, in 2022, Dobbs v. Jackson narrowed the scope of a, quote, right to privacy, so each state could determine for itself whether abortions are legal or illegal. Today, we remain as divided as ever over this troubling issue. Despite the framers' intentions, the Supreme Court is an epicenter for hotly contested political issues. In Buckley v. Vallejo in 1976 and the famous Citizens United case in 2010, the court struck down campaign finance laws, opening the floodgates for the wealthy to influence elections. And of course, there's Bush v. Gore in the year 2000. With almost 6 million votes cast, a difference of only 537, questions arose. Do you or don't you count a ballot if the hole is not completely punched out? The infamous hanging chads. The Florida Elections Commission ordered a careful recount, but the United States Supreme Court overturned that order and let the initial results stand. In the near future, the Supreme Court might once again have the final word in a hotly contested election. Can it be trusted as an impartial referee? The framers did worry about political interference with the course of justice. To shield justices from public opinion, they allow them to serve during good behavior, essentially for life. But back then, the life expectancy in the United States was 38. A person born today is expected to live more than twice as long, till the age of 78. Half of the first 12 Supreme Court justices served less than 6 years. Compare that with recent times. Sitting Justice Clarence Thomas has served for a third of a century. So did William Rehnquist, Chief Justice prior to John Roberts. Antonin Scalia, conservative icon, served for 29 years, while Ruth Bader Ginsburg, a liberal icon, for 27 years. Our founders did not foresee this, yet to change it, we would have to amend the Constitution. 2/3 of the Senate, along with 2/3 of the House of Representatives and 3/4 of the state legislatures would all have to agree. With our current partisan landscape, that just won't happen. Whichever party suspects it might lose power will oppose it. Today, we still hear the complaint the framers worried about. How can unelected officials overturn the actions of people whom we did elect? One delegate to the Constitutional Convention, Delaware's John Dickinson, shared this concern, but with a caveat. I strongly oppose the power of judges to set aside a law. No such power ought to exist. But at the same time, I am at a loss what expedient to substitute. Here's the rub. If not justices of the Supreme Court, whose life work is to understand the law, who else can keep an overzealous Congress or a power-hungry president in check? The Supreme Court, by default, is stuck with the task of protecting our Constitution. James Iredell, a justice on the first Supreme Court, put it this way: a constitution is not a mere imaginary thing about which 10,000 different opinions may be formed, but a written document to which all may have recourse. If all have recourse to one federal constitution, and if its stipulations and rules supersede any others, judges can cite that document in order to toss out unjust laws. Without the clarity that a constitution provides, civil unrest will ensue. Constitutional guarantees protect minorities and minority opinions as well. Without these, people will join the majority just to be safe. They will be forced to sacrifice reason, conscience, and duty to the preservation of temporary popular favor. We have lived by the supreme law of the land for 237 years. Can we, will we, continue to do so?